you for participating in today's webinar. We're going to cover the Families First Coronavirus Response Act, what employers need to know. Just as an outset, I want to make sure everybody's aware that many things with regard to this law, the CARES Act, the components of the law are changing as we get a better understanding based on government interpretations and other information from other sources. In this regard, I'll just be upfront with you. I changed this presentation several hours ago based on some additional information we received from the U.S. Department of Labor. We also, those of you who are in Georgia, Governor Kemp signed an executive order yesterday, late in the day, with regard to shelter in place. So in addition to the things I'm going to talk about today, I'm going to basically talk about the federal laws and the acts that are contained therein. You need to pay attention to state laws, local laws, that could be county laws, county orders, and also city and other related orders. So having said that, let's go ahead and get rolling here. Okay, let me just talk, what I'm going to talk about today and also give you an overview. As probably most of you know, President Trump signed the Family First Act on March 18th. The U.S. DOL, Department of Labor, started issuing guidance with regard to some of the gray areas contained in the law, and as well as other laws. It's been doing so nearly daily. We've had to go back and look at interpretations from the United States Department of Labor going back many years to get some kind of idea of what the definitions mean. But we, as I said at the outset, we are receiving information on nearly a daily basis, sometimes more than several times during the day, that are help clarify some of the nuts and bolts of this law as well as the other law. As most of you already know, the leave provisions under the Family First Act went into effect on April 1. Many of you may not know that the leave provisions, that's the Employee Paid Sick Leave Act and the Emergency Family Medical Leave Expansion Act, sunset on December 31st of this year. Now, in the Family First Act, it has two acts, two subparts, the Emergency Paid Sick Leave Act, the Emergency Family Leave Expansion Act. I'm going to talk about those today. I'm going to talk about or touch on, I can't get into all the aspects of these things, but the reimbursement to employers as tax credits. I'm going to provide some scenarios. I'm going to discuss the small business paycheck protection loans. I'm going to touch on the CARES Act. And then, because of the time constraints and the other webinars that I've done, the number of questions are very fact specific. So what I have done is I have the most asked questions, I've put them into frequently asked questions. Some of the information I pulled directly from the U.S. Department of Labor's website, but I'm going to have frequently asked questions at the end. I'm going to move through this as quickly as I can because I know your time is valuable. And if you have questions, the first place you should go is our website, fisherandphillips.com. We have a task force of attorneys across the country that have put together information essentially in the form of alerts, which are updated daily during the day based on new information that you receive. That's a very good resource for you. I can tell you that we try very hard to make sure that we provide accurate information based on the information that we have, the interpretation, et cetera, at the time that the information is produced. But that's a good place for you to go for information. Let's start off talking about the Emergency Paid Sick Leave Act. Some basics, qualifying employers and employees. Employers with less than 500 employees, 1 through 499 employees is covered. some of the issues that have come up is, how do you count employees? What about separate entities? Are they combined? How do you deal with those situations? Well, on March 24th, the USDOL had a Q&A, and they provided some additional information. In this regard, with respect to coverage and counting employees and separate entities, with regard to the Emergency Paid Sick Leave Act, employers need to look at the joint employer rules under the Fair Labor Standards Act. Interestingly, these rules were updated in December of 2019. So there's not a lot of case law or anything else out there on these new rules. Now, there is a vertical joint employment component and a horizontal joint employment component. With regard to vertical joint employment, there's several factors that an employer or employers should look at and no one factor is determinative. Now, if you look back at the history of the joint employer analysis, different court systems across the country have different factors that they put more weight on. But right now, as far as we're concerned, and with the fact that this is new, all the factors need to be evaluated and weighed and balanced to determine, whether a joint employment situation exists. But the putative joint employer must actually exercise control over one or more of the following factors. Now, this is actual control, direct control. Prior to December of 2019, there had been a component to the determination with regard to indirect control. But right now, it's exercised effectively joint control. And the factors they look at is the putative joint employer's ability to hire and fire employees and the employer in question, supervise and control the employee's work, schedule or oversee or direct conditions of employment to a substantial degree, determine whether the employer determines the employee's rate and method of payment, and whether the employer maintains employees' employment records. Again, there is no single factor that controls. And again, it's a new test. Now, with regard to horizontal joint employer employment, the test is whether the employee working for two or more entities is actually more akin to whether the employee is working for a different divisions or departments within a company. The factors they look at, or going to look at with regard to horizontal joint employment, is whether the arrangement between the entities, the potential joint employers, to share, whether there's arrangement between the two employers to share the employee's services, whether the employee is acting directly or indirectly in the interest of the other employer, whether they share control over the employee, and particularly if the employer controls or is controlled by or is under common control with the other employer. Now, this is a balancing, just like with regard to the joint employer employment test. So, those are the factors you have to look at to determine whether you are a joint employer and then have coverage under the Emergency Paid Sick Leave Act as to the count of employees. We are looking for further guidance in this regard, and we're getting additional information as we move forward. Any employee who works for an employer is eligible for employee emergency paid sick leave under the Act. Again, it must be the company must be covered employer and have 1 to 499 employees. Now, the qualifying reasons. For the following reasons, the employee is eligible for paid sick leave under the Emergency Paid Sick Leave Act. Employers must provide paid sick time to the extent the employee is unable to work or telework due to the need for leave, because there's 6 criteria here. The employee is subject to federal, state, or local quarantine or isolation order related to COVID-19. 2, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to coronavirus. The employee is experiencing symptoms of COVID-19 and is seeking medical diagnosis. The employee is caring for an individual who is subject to an order or self-quarantine as described above. The employee is caring for a son or daughter if the school or child care facility is closed or unavailable. The employee is experiencing any other substantial condition specified by the HHS, and this is a catch-all. So what we have done is prepared a form, a leave request form, where the employee will provide information to the employer as to which type of leave or which criteria, one of the 6 factors he or she falls under to determine whether that individual is eligible for leave. Now, with regard to the employee's wages, if the employee is sick, the employee is entitled, and this is full-time employees, to 80 hours of paid sick leave. Now, the initial House bill referred to 2 weeks or 14 days. Right now, it's 80 hours. They're basically looking at 10 work days. As to part-time employees, pay is based on the employee's average number of work hours in a 2-week period. Therefore, you calculate the hours of leave based on the number of hours the employee is normally scheduled to work. If the normal scheduled work hours are unknown, or if the part-time employee's schedule varies, you look back over the past 6 months and use an average to calculate the average daily hours worked. If the employee is employed for less than 6 months, the average number of hours per week the employee would normally be scheduled to work is used for the determination of the wages. Now, at the employee's regular rate, for reasons 1, 2, 3, the employee receives pay under the Paid Sick Leave Act. The employee is compensated at the higher of their regular rate of pay, the federal minimum wage or local minimum wage. Now, I talked about 1, 2, 3. The 1, 2, 3 are these qualifying reasons. The employee is subject to federal, state, or local quarantine or isolation order. The employee has been advised by a healthcare provider to self-quarantine, or the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Now, the employee is eligible for 2/3 of his or her regular rate of pay for qualifying reasons 4, 5, 6. So with regard to these qualifying reasons, the employee is caring for an individual subject to a self-quarantine order, or the employee is caring for a son or daughter if school or child care is closed or unavailable, or the employee is experiencing any other substantial condition specified. The employee is to be compensated at 2/3 his regular rate of pay. Now, the benefit is capped at the following levels. That's $511 per day, or $5,110 in aggregate per person, and this is for qualifying reasons 1, 2, and 3. For qualifying reasons 4, 5, and 6, it's capped at $200 per day and $2,000 in aggregate. So over the 80 hours, that relates to the per day payment and the aggregate amount. Now, there are certain exemptions from the Paid Sick Leave Act, and the first exemption is an employee who is a healthcare provider or an emergency responder. That employer may elect to exclude such an employee from the application of this section. Now, near the end of this presentation, I'm going to provide additional information covering healthcare provider and the emergency responder. So it'll provide a little more clarification to you. Now, under the Act, under the law, the Secretary of Labor has the authority for good cause to issue regulations. And the regulations would cover the following items: to exclude certain healthcare providers and emergency responders from the definition of eligible employee, to exempt small businesses with fewer than 50 employees from leave to care for a son or daughter if school or child care is closed or unavailable, when the imposition of such requirement would jeopardize the viability of the business as a going concern. Now, this is an important exemption here with regard to small businesses. I have a number of clients I've discussed this issue with. And because of their questions, I'm going to cover it a little bit more in detail in a moment. There's also another catch-all here. The Secretary of Labor has the authority for good cause to issue regulations as deemed necessary. Now, there's some additional general rules. Sick leave does not carry over. The employer may not require an employee as a condition of paid leave to find a replacement to cover his or her scheduled hours. Importantly, the employer may not require an employee to use other paid leave, PTO, vacation, etc., provided by the employer before using this paid sick leave. Now, there's certain notice requirements associated with not only the Emergency Paid Sick Leave Act, but also the Emergency Family Medical Leave Expansion Act. Employers are required to post a notice regarding the requirements of the law. Now, I'm sure many of you, if not most of you, are working remotely, if at all. For that reason, you don't have, the usual is to post the notice on an employee bulletin board. If employees aren't at work, this is not, the posting on an employee bulletin board is not sufficient. Or if you have employees, some working at your facility and some working remotely, you need to take steps to make sure that the notice that these employees are working remotely who are not at work receive the notice. So send it to them via email, okay? The Secretary of Labor has created a model notice. You can find it on our website under the Alerts tab. You can also find it on the Secretary of Labor's Secretary of Labor's website. If you go to the Secretary of Labor's website, there's two model notices. Make sure you download the correct one. One applies to government employees and one applies to employees in the private sector. After the first workday or portion thereof, an employee receives paid sick leave. The employee may require the employee to follow reasonable notice procedures in order to continue receiving such paid sick time. This is important because if you can require an employee to call in to make you aware of the work he or she is completing, make sure that you're aware of their availability, etc. So there's no problems or no issues with that requirement. Let's move on to the Emergency Family and Medical Leave Act. Again, like the Emergency Paid Sick Leave Act, it covers employers with less than 500 employees. The count of employees and the combination of entities to determine whether an employer is covered, in other words, under 500 employees, consists of two tests. There's a joint employer test, which I discussed with regard to the Employee Paid Sick Leave Act, but there's also another test that employers have to consider, and it is the Integrated Employer Test. Now, this is a test that has been used, is related to coverage under the Family Medical Leave Act. So there is information out there on the Integrated Employer Test. The Integrated Employer Test is based on the totality of the employer relationship between the two entities or two or more entities. Based on the Integrated Employer Test and also the Joint Employer Test, the employee count of related entities could be combined together, added together for determination of whether the employer falls within the 500 employee limitation. The factors that are considered are, first one is common management. Who has the control over the day-to-day business operations, and who has authority to hire and fire the employees in question. They look at another factor is the interrelationship between the employer's operations, the two companies or two or more companies' operations. You know, is there a centralized control of labor relations? And this can happen if you have a company that's a parent company, and you could have subsidiaries that are, because of the integrated test, to be added together. And often the parent has a centralized control over labor relations. And then the fourth factor and last factor is the degree of common ownership of the companies. We are expecting, we have received and we're expecting additional guidance from the US DOL in this regard. Any employee who has worked for the employer for 30 days prior to leave and has a qualifying reason is eligible for leave under the Emergency Family Medical Leave Act. Now, most of you HR professionals out there know that there is a requirement under the FMLA that the employee have worked 1,250 hours during the previous 12 months. This is not the requirement. That requirement does not apply to the Emergency Family Medical Leave Act. The requirement is the employee has worked for the employer for 30 days prior to the need for the leave. Now, qualifying reasons, they're similar to the Emergency Paid Sick Leave Act, but more limiting. An employee under the Emergency Family Medical Leave Act is eligible for 12 weeks of job protected leave when the employee is unable to work or telework due to the need for leave to care for a son or daughter under 18 years of age. If such employee, their school or place of daycare, et cetera, is closed, or the child care provider of such a son or daughter is unavailable due to a public health emergency. In other words, has the school place of care been closed by a government entity? Most likely, the FMLA definition of son and daughter will apply to these circumstances. Now, a public health emergency is an emergency with respect to COVID-19 declared by any federal, state, or local authority. So it's fairly broad. Just for your edification, these laws are, the focus of them is to keep employees working, and if they're unable to work for reasons beyond their control, they're entitled to certain benefits, pay, etc., so that they can continue to survive, make payments, live, etc. So questions will likely be construed in their favor going forward. So keep that in mind if you have a question and it's really not clear based on the available information at the time, how if it's evaluated later, where the government entity or court would come down. Now, how does the Emergency Family Medical Leave Act work? The first 10 days of Emergency Family Medical Leave Act may be unpaid, okay? Now, I say maybe because those first 10 days may be covered by the Emergency Paid Sick Leave Act. So you could have an employee that qualifies for the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Act and has paid leave for the entire 12 weeks. There are situations where an employee will qualify for the Emergency Paid Sick Leave Act, but not for the Emergency Family Medical Leave Act. Often this is because they don't have children, or there's another parent, for example, in the home that can take care of the kids. Now, remember, there's a difference. 1, 2, 3 is not included in the Emergency Family Medical Leave Act. Essentially, it's 4, 5, 6, as I talked about earlier. As I said here, as you look, the employee is unable to work or telework due to a need for leave to care for a son or daughter under 18 years of age. This is the qualifying reason. The emergency paid sick leave provides for additional qualifying reasons. Okay? An employee may elect to substitute accrued PTO, vacation, or sick leave to cover any portion of the first 10 days. But like the Emergency Paid Sick Leave Act, you can't force an employee or require an employee to use accrued PTO, vacation, or sick leave in place of the benefit. Okay? Eligible employees may take paid sick leave for the first 10 days of the Emergency Family Medical Leave Act, as I just discussed. Now, there's potentially different pay levels under the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Act. After the first 10 days, the employee is compensated at 2/3 of the regular rate. With regard to part-time employees or employees that have an irregular schedule, pay is calculated in the same manner as the Emergency Paid Sick Leave Act. Under the Emergency Family Medical Leave Act, pay is capped at $200 per day and $10,000 in aggregate per employee. In general, the Emergency Family Medical Leave Act has the same exemptions as the Emergency Paid Sick Leave Act. Now, job restoration and reinstatement. It varies based on the number of your employees. If you have 25 or more employees, the traditional restoration obligation under the FMLA applies. Employees must be restored to the same or equivalent job. If the employer has fewer than 25 employees, the traditional restoration obligations don't apply. In that regard, the traditional provisions apply or do not apply if the employee takes Emergency Family Medical Leave Act, the position does not exist due to economic conditions or other changes in operating conditions of the employer that affect employment and are caused by a public health emergency during the period of leave. So, it's a good probability, or 25. There's an employer with 25 or fewer employees. Fewer than 25 employees has more leeway with regard to a job restoration of the employee after the 12 weeks of leave. The employer makes reasonable efforts to restore the employee to an equivalent position with equivalent pay, benefits, or other terms. And if reasonable efforts to restore the employee to equivalent position fail, the employer makes reasonable efforts to contact the employee if an equivalent position becomes available during the 1 year period thereafter. Now, small employers, 25 and fewer employers, don't have or are considered not to have the same levels of flexibility, the same ability to restore an employee to his or her previous job. So they're provided greater protections under the law. Now, notice requirements. I already talked about this. Again, if you post it, if you still have employees at your work site, if you have employees working remotely, you need to email or mail it to them. Now, with regard to giving notice to the employer of the necessity for leave, if it is foreseeable, the employee shall provide the employer with notice of the leave as it is practicable. If he or she knows about it, has enough advance notice, they should notify you as soon as possible. But there may be a situation where it's not foreseeable. For example, employee, an order could be promulgated, could be implemented that specifies that child care facilities, for example, must be closed. That could happen today, and tomorrow the employee gives you notice. That would be satisfactory. Now, I'm going to talk about tax credits here. And it's under both the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Act. Employers subject to the requirements of those acts under the Family First Coronavirus Recovery Act are entitled to a tax credit equal to the amount of the paid family and medical leave requirements paid by the employer. The tax credits for qualified wages are capped at $200 per day and $10,000 per calendar quarter per employee. The tax credits are applied against the employer's Social Security taxes, but employers are reimbursed if their costs for qualified leaves exceed the taxes they will owe. Now, I'll give you some examples here of that. The IRS has said it will be issuing additional guidance to address the cash flow challenges created by this tax credit. Because you think about it, you're getting a tax credit later, but you're having to expend funds now. The IRS guidance will likely allow employers to retain amount of payroll taxes equal to the amount of paid leave that they paid, rather than deposit them with the IRS in anticipation of the tax credit. Now, here's an example for you. If an eligible employer paid $5,000 in sick leave and is otherwise required to deposit $8,000 in payroll taxes, including taxes withheld from all employees, the employer could use up to $5,000 of the $8,000 of taxes it was going to deposit for making qualified leave payments. The employer would be required under the law to deposit the remaining $3,000 on its next regular deposit date. So there is some relief here. Just keep that in mind. Now, I'm going to touch on some scenarios here that relate to these acts. The first scenario, Sally has been employed full-time for 20 days at a call center, which employs 40 people. Sally is not eligible to receive any paid leave off under her employer's policies. She has a sore throat and a fever and of 100.7 and cannot report to work. Sally is waiting to be seen by a doctor. What benefits is Sally entitled to while she is working? She's entitled to leave under the Emergency Paid Sick Leave Act, 80 hours of pay at a regular rate. Sally would not be entitled to emergency family medical leave because she was not employed for at least 30 days prior to the first day of her leave. Okay, so there's that 20 days she worked full time, but it's a 30-day requirement on the Emergency Family Medical Leave Act. So you really have to go through these different requirements to make sure that or determine whether the employee is eligible. Now, scenario 2, Sally has been employed full-time for 40 days at a call center, which employs 40 people. As of today, Sally has accrued 3 days of paid time off under her employer's policies. The school where Sally's 4th grade daughter attends is closed until the end of April. Sally is unable to work from home during this time. What benefits is Sally entitled to receive during this time? She's entitled to emergency paid sick leave, 80 hours at 2/3. Remember from when I talked about earlier, this is for reasons 4, 5, 6. 2/3 her regular rate of pay. She's entitled to emergency family medical leave up to 12 weeks of job protected leave. The first 10 days are unpaid under the Emergency Family Medical Leave Act, but could be paid at her 2/3 her regular rate of pay under the Emergency Paid Sick Leave Act. After the 10 days, salary is under the Emergency Paid Sick Leave Act, Sally is paid at 2/3 her regular rate of pay. It's up to Sally whether she elects to use her 3 days of PTO, but she is not required to do so. So please keep that in mind when you're moving forward on these scenarios, in these situations. A few things to keep in mind. You need to pay attention to state or local laws. As an employer, you essentially have to comply with all the various laws. In general, you're going to need to comply with the most strict law. Many states and local jurisdictions have their own paid sick leaves and family medical leave laws. That they may add benefits in addition to new federal requirements. Many states and locals who have these laws are working to amend them to add new requirements based on the Family First Coronavirus Recovery Act and also the CARES Act. Now, the CARES Act. Under the CARES Act, and this is interesting because we get a ton of questions on these subjects. Small business paycheck protection loans. This includes small businesses up to $10 million. They can receive up to $10 million to help with normal payroll and other costs. This does not include costs to provide emergency paid sick leave or emergency family medical leave paid leave. The loans may be or will be forgiven. However, the amount of forgiveness can be reduced if you lay off workers or reduce their compensation more than 25%. The reduction will be completely avoided if the employer, by June 20th to 2020, rehires employees that were laid off on or after February 15th, 2020. I've had a number of clients a number of clients who have furloughed, laid off, terminated employees because of business conditions associated with the coronavirus pandemic. If you reemploy them by June 20th of 2020, you may become eligible for paycheck protection loans. You need additional information on this, but that's a possibility. Now, another CARES Act provision is employee retention tax credit. This tax credit is not available if you get a paycheck protection loan. Tax credit for payroll for the payroll tax for 50% of wages for the first $10,000 of compensation for employers whose operations were fully or partially suspended due to coronavirus, or gross receipts declined by more than 50%. This is another, if for some reason the paycheck protection loan is not available to you, or this may be a better option for you. But again, you can't combine them. And then there's a payroll tax holiday in the CARES Act, which allows employers to defer a portion of the Social Security taxes over the next 2 years. The first half would be due on December 31st of 2021, with the remaining half due on 12/31/2022. Now, I'm sure many of you are familiar with what's going on with unemployment insurance. The federal government has infused significant funding into the state's unemployment compensation accounts. And this law, interestingly, provides workers with $600 per week from the feds, which is in addition to state unemployment compensation for up to 4 months. This is interesting because if you look at it, some employees could earn more money, let's say look on a per hour basis, more money on unemployment than they can make working for you. Now, this is an interesting situation because some employers are looking at it, they want to keep employees employed so they get paid, etc. But the reality is that your workers could possibly make more money on unemployment. In other words, if you terminated or laid them off. But remember now, if you terminate an employee or lay off employee, which is considered different than furloughing. Furloughing may not be considered a termination. They may, or they will. They depending on your health plan, they may be subject to COBRA notification with regard to continuing their health care benefits. Interestingly, the CARES Act extends unemployment compensation insurance towards independent contractors, 1099 employees, and gig workers. Now, also under the CARES Act, there's mid-sized business loans, which are to be administered by the Treasury. They're for employers that have between 500 and 10,000 employees. There's a little provision that was sort of snuck in the provisions covering this loan, this mid-sized business loan, which provides that a business who receives this loan must make a good faith certification that it will remain neutral in any union organizing effort for the term of the loan. So unlike under normal conditions where an employer has free speech rights to state its position against or for unions for that matter, that right would be given up by the employer as a provision or as a requirement associated with the mid-sized business loan. For purposes of the Emergency Federal Family Medical Leave Act, when an employee was laid off on or after March 1st, 2020, who has worked for 30 of the last 60 calendar days before layoff and is rehired, may be eligible for benefits under Emergency Family Medical Leave Act. They do not have to restart the 30 days counter. For example, in the first scenario where Sally had 20 days, she was eligible for leave under the Emergency Paid Sick Leave Act, but not under the Emergency Family Medical Leave Act because she only worked 30 days. If she was put back to work, Sally would be eligible for benefits under the Emergency Family Medical Leave Act 10 days thereafter. So keep that in mind. Now, some frequently asked questions. And this applies to exemptions for small employers. The question is, our company has fewer than 50 employees. Is there an exemption for our company? Now, I mentioned this earlier with regard to the Emergency Paid Sick Leave Act, okay? There is an exemption, and here is what's required to be able to take that exemption. According to the most recent Q&A from the U.S. Department of Labor, an employer with fewer than 50 employees is exempt from providing paid sick leave due to school or place of care closures or child care provider unavailability, and expanded family medical leave due to school or place of care closures or child care provider unavailability when doing so would jeopardize the viability of the small business as a concern. Now remember that this is with regard to the Emergency Paid Sick Leave Act. This applies to requirements or eligibility requirements 4, 5, and 6, not 1, 2, and 3. Now, to claim the exemption, the small business must do the following. The provision for paid sick leave or expanded medical leave will result in the small business's expenses or financial obligations to exceed available business revenues and cause the business to cease operating at a minimal capacity. The absence of the employees requesting paid sick leave or expanded medical leave would entail a substantial risk to the financial health or operational capabilities of the small business because of their specialized skills, knowledge of the business or responsibilities, etc. There are not sufficient workers who are able, willing, and qualified, and who will be at the time and place needed to perform the labor and services provided by the small employer. Okay, so this is what's necessary for the exemption. Now, it's important to note that the requirements, these factors, the executive or top manager in the firm or the company needs to attest to these meeting or to satisfying these requirements. Okay. If your company is required to shut down due to a government order mandating the closure of our businesses, would the employees be covered by the new law? What if the company closes voluntarily for lack of business? Now, this is again based on the most recent DOL guidance, which was issued March 26, which appears to say that if the employer closes his business in whole or in part for lack of business or due to a government mandated shutdown before or after April 1, employees who are impacted by the closure are not entitled to benefits under either the Emergency Paid Sick Leave Act or the Emergency Family Medical Leave Act. So you could have a business that is based on the recent state of Georgia shelter-in-place order that may require you to close. If that's the case, you would not be the employees would not be entitled to benefits under either of the either act, the Emergency Paid Sick Leave Act or the Emergency Family Medical Leave Act. If the employer closes the work site while an employee is on paid sick leave or expanded family medical leave, what happens? Well, if the employer closes while the employee is on paid sick leave or expanded emergency family medical leave, the employee must pay for any paid sick leave or expanded medical leave used before the employer closes. As of the date the employer closes, the employees are no longer entitled to paid sick leave or emergency family medical leave, but may be eligible for unemployment compensation insurance benefits. This is another thing, another question that I've been getting from employers wanting to know, what the heck do I do if I can't stay open? If the employer remains open but furloughs employees, we say, for example, reduces an employee's hours or days of work on or after April 1, can the employee receive paid sick leave or expanded family and medical leave? No. If the employer furloughs employees because it does not have enough work or business for employees, even if the reason is due to a government mandated closure, employees are not entitled to take emergency paid sick leave or leave under the Emergency Family Medical Leave Act. Be careful though. There could be, if you shut down or furlough, lay off, terminate a number of employees, the employer could have additional obligations if they have 100 or more employees to comply with the WARN Act. We have a lot of questions we're receiving a lot of questions with regard to this. We have worked with many employers in relation to this. It's dependent on your particular situation, but there are some protections we have been able to come up with that can circumvent some of the WARN Act issues. Now, temporary closures, intent to rehire. If an employer closes its work site, this is on or after April 1st, but tells employees that it will reopen it sometime in the future, can employees receive paid sick leave or paid emergency family medical leave during the period of closure? No. So long as the work site is closed, the answer is no. If the employer closes a work site even for a short period of time, employees are not entitled to paid sick leave or emergency family medical leave. In calculating pay due to employees for work overtime, must overtime hours be included? Under the Emergency Family Medical Leave Act, the law requires employers to pay employees for hours the employee would have been normally scheduled to work, even if that is more than 40 hours per week. For example, under the Emergency Paid Sick Leave Act, employees receive only 80 hours of pay if they are a full-time employee. So if they are normally scheduled to work 40 hours per week, you would pay them 45 hours of sick leave for the first week and only 35 hours the second week for a maximum of 80 hours. Okay, so this is, so if you got an overtime employee under the Emergency Paid Sick Leave Act, they're only entitled to a total of 80 hours. So if they work 45 hours per week, they get 45 hours of pay, or pay based on 45 hours the first week and only 35 hours for the second week. But you always got to recall, as I discussed earlier, the caps. You need to make sure that that you're including in your determination as to what you pay them the caps under each act. Employee paid sick leave, partial day absences. May an employee take paid sick leave intermittently while working at the usual work site as opposed to teleworking? This depends on why the employee is taking paid sick leave and whether the employer agrees. Okay, you need to evaluate it and determine whether the employee is eligible. Unless the employee is teleworking, paid sick leave for qualified reasons related to the coronavirus must be taken in full day increments. It cannot be taken intermittently if the leave is being taken because the employee is caring for an individual who is ill or quarantined. Unless the employee is teleworking, once he or she begins taking paid leave for one or more of the qualifying reasons, he or she must continue to take paid sick leave each day until he or she either uses the full amount of the paid sick leave, remember the caps, or no longer has a qualified reason for taking paid sick leave. This limit is imposed because if the employee is sick or possibly sick from the coronavirus, or caring for an individual who is sick or possibly sick with the coronavirus, the intent of the Family First Coronavirus Recovery Act is to provide such paid leave as necessary to keep the employee from spreading the virus to others. Now, emergency family medical leave, partial day absences. Can an employee take emergency family medical leave intermittently if the employee only needs to provide child care for 3 days of the week? On the Emergency Family Medical Leave Act, the answer is yes, but only with the employer's permission. Intermittent emergency family medical leave is only permitted when the employer and the employee agree upon such a schedule. For example, if the employer and employee agree, an employee may take emergency family medical leave on Mondays, Wednesdays, and Fridays, but not Tuesdays and Thursdays. Just an example. While the employee's child is at a home because the child's school or place of care is closed, or child care is unavailable due to the coronavirus and related reasons for the duration of the employee's leave. So it's up to you, it's up to the employer to decide whether intermittent emergency family medical leave is going to be allowed. Now, employee leave requests. Is there a process whereby employees should apply for leave for the Emergency Family Medical Leave Act or the Emergency Paid Sick Leave Act? Can they supplement the 2/3 pay with leave for leave when the child's school is closed, or they must provide care with PTO or vacation time? First off, we recommend that you have a leave request form. Our leave request form was updated several days ago based on additional guidance from the IRS. The IRS provided guidance that stated or informed employers what documentation they needed to be eligible for tax credits under the Emergency Paid Sick Leave Act. So, if you need those forms, they're on our website, or you can email me and I will send them to you. We recommend that you have the employees complete a form. There should be, we recommend that there be a separate form for the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Act because of the different requirements, etc. And the form is very simple to complete. they check the box and they just fill in some blanks. You got to make sure it may be necessary. As I just said, we updated our form based on IRS guidance for emergency emergency paid sick leave earlier this week. But you got to keep abreast of it. There may be additional requirements based on guidance or clarifications provided by the USDOL or the IRS or some other government agency that necessitates a revision of the forms. Now, retroactive application of these laws, these acts. Is the legislation retroactive? Do employees have to pay employees for time already taken off before the law goes into effect? For example, the employee was furloughed or the employee was out because of child care issues, etc. It is not retroactive. Employers should follow policies and practices for time taken off before the law goes into effect. So the law took effect April 1, 2020. Before the law went into effect, your policies and procedures in place at the time are applicable to the situation. Your policies and procedures need to be applied consistently with the manner they were applied prior to April 1. Now, medical certification. Can employers require employees to provide certification, medical certification? Well, according to the most recent guidance from the U.S. Department of Labor, if an employee takes paid sick leave, the employee must provide to the employer supporting documentation as specified in applicable IRS forms, instructions, and information for purposes of the refundable tax credit, which I just talked about, okay? If you look at the form, you'll see a description of the information. We included it on the form. According to the most recent U.S. DOL guidance, if the employee takes expanded leave, family medical leave to care for a child whose place of care is closed, unavailable, etc., the employer must require the employee to provide documentation in support of the leave, such as a notice that has been posted on a government school daycare website. But in reality, it should be relatively easy for an employer to obtain documentation or make a determination to verify that the school or child care facility, et cetera, government care facility or whatever is closed. Now, there are exemptions for healthcare providers and emergency responders. I touched on this earlier. According to the U.S. Department of Labor questions and answers, a healthcare provider is defined as anyone employed at a doctor's office, any doctor's office, a hospital, healthcare clinic, a healthcare center, a clinic, a post-secondary educational institution offering healthcare instruction, a medical school, local health department or agency, nursing facility, requirement facility, nursing home, home healthcare provider, and any other facility that performs laboratory or medical testing, pharmacy or similar institution, employer or entity. So pretty broad, okay? The definition includes also any permanent or temporary location where medical services are provided that are similar to such institutions. In some parts of the country, you may be aware that they have testing facilities and things like that that are part of a medical service, of a medical institution. That would be subject to the exemption. Now, the definition includes any individual employed by an entity that contracts with any of the above institutions. Okay, so it's not only the direct employees, but they're covered individuals of any entity that contracts to provide services to the above referenced institutions, employers, or entities to provide services or to maintain the operation of the facility. This also includes anyone employed by any entity that provides medical services, produces medical products, or is otherwise involved in the making of coronavirus-related medical equipment, tests, drugs, vaccines, diagnostic vehicles, or treatment. It also includes any individual that the highest official of a state or territory, including the District of Columbia, determines as a healthcare provider necessary for that state or the territories or District of Columbia's response to the coronavirus. The U.S. Department of Labor encourages employers to be judicious when using this definition to exempt healthcare providers from the provision of the Family First Coronavirus Recovery Act to minimize the spread of coronavirus-19. So, who is an emergency responder? Well, according to the DOL, an employee who is necessary for the provision of transport, care, health care, comfort, and nutrition of such patients, or whose services are otherwise needed to limit the spread of the coronavirus. This includes, but is not limited to, military or National Guard, law enforcement officers, correctional institution personnel, firefighters, emergency medical services personnel, physicians, nurses, public health personnel, emergency medical technicians, paramedics, emergency medical personnel, 911 operators, public works personnel, and persons with skills or training in operating specialized equipment or other skills needed to provide aid in a declared emergency, as well as individuals who work for such facilities, employing these individuals and whose work is necessary to maintain the operation of the facility. That's a mouthful, but you can see here that the definition is fairly broad. So those individuals that fit within these exemptions are exempt from Emergency Family Medical Leave Act, the Emergency Paid Sick Leave Act. I've tried to limit this to an hour. As to questions and things like that, again, we will limit it to an hour. So we're going to move on at this point. Now, we may be providing additional webinars for possibly under the CARES Act, depending on questions we get from members of the Forsyth County Chamber of Commerce and other clients and entities, etc. I'd like to take a minute and thank the Forsyth County Chamber of Commerce for sponsoring this webinar today. Key individuals over there, well, all of them are key for that matter, but James McCoy, Jimmy Lane, Laura Stewart, Scott Evans are all working, and others are all working very hard to try to get information for members and others in Forsyth County and even the surrounding areas, so that we could all get through this crisis, this pandemic. As I mentioned earlier, our website, FisherPhillips.com, has answers to many questions that you may have. We are constantly updating the information on that website. We have attorneys working from our offices all over the country working on this. They all have different expertises in different subject matter, and we're all working benefits, OSHA, Fair Labor Standards Act. All of us are working together to provide information that is up to date and useful for you in addressing your questions. If you need forms or other information, please do not hesitate to send me an email, or you can call me for that matter, and I will attempt to respond as quickly as possible and get you the information that you're requesting. Again, I'd like to thank you for joining us today, and I wish everyone a healthy, good health during this situation. And I'm looking forward to this being quickly over. So I'm still I'm still an optimistic person. So we all need to hang in there and get through this together. But again, thank you very much for joining us today, and thank you for the Forsyth County Chamber of Commerce. You all have a good day.